Rule 41. Appeal from the Regional Trial Courts. Section 1. Subject of Appeal. An appeal may be taken from a judgment or final order that completely disposes of the case or of a particular matter therein when declared by these rules to be appealable. No appeal may be taken from an order denying a petition for relief or any similar motion seeking relief from judgment, an interlocutory order, an order disallowing or dismissing an appeal, an order denying a motion to set aside a judgment by consent, confession, or compromise on the ground of fraud, mistake, or duress, or any other ground vitiating consent, an order of execution, a judgment or final order for or against one or more of several parties or in separate claims, counterclaims, cross-claims, and third-party complaints while the main case is pending, unless the court allows an appeal therefrom, and an order dismissing an action without prejudice. In any of the foregoing circumstances, the aggrieved party may file an appropriate special civil action as provided in Rule 65. Section 2. Modes of Appeal. Ordinary Appeal. The appeal to the Court of Appeals in cases decided by the Regional Trial Court in the exercise of its original jurisdiction shall be taken by filing a notice of appeal with the court which rendered the judgment or final order appealed from and serving a copy thereof upon the adverse party. No record on appeal shall be required except in special proceedings and other cases of multiple or separate appeals where the law or these rules so require. In such cases, the record on appeal shall be filed and served in like manner. Petition for review. The appeal to the Court of Appeals in cases decided by the Regional Trial Court in the exercise of its appellate jurisdiction shall be by petition for review in accordance with Rule 42. Appeal by certiorari. In all cases where only questions of law are raised or involved, the appeal shall be to the Supreme Court by petition for review and certiorari in accordance with Rule 45. Section 3. Period of Ordinary Appeal. Appeal in habeas corpus cases. The appeal shall be taken within 15 days from notice of the judgment or final order appealed from. Where a record on appeal is required, the appellants shall file a notice of appeal and a record on appeal within 30 days from notice of the judgment or final order. However, an appeal in habeas corpus cases shall be taken within 48 hours from notice of the judgment or final order appealed from. The period of appeal shall be interrupted by a timely motion for new trial or reconsideration. No motion for extension of time to file a motion for new trial or reconsideration shall be allowed. Section 4. Appellate Court, Docket, and other lawful fees. Within the period for taking an appeal, the appellant shall pay to the Clerk of Court which rendered the judgment or final order appealed from the full amount of the appellate court, docket, and other lawful fees. Proof of payment of said fees shall be transmitted to the appellate court together with the original record or the record on appeal. Section 5. Notice of Appeal. The notice of appeal shall indicate the parties to the appeal, specify the judgment or final order or part thereof appealed from, specify the court to which the appeal is being taken, and state the material dates showing the timeliness of the appeal. Section 6. Record on Appeal, Form and Contents thereof. The full names of all the parties to the proceedings shall be stated in the caption of the record on appeal, and it shall include the judgment or final order from which the appeal is taken, and, in chronological order, copies of only such pleadings, petitions, motions, and all interlocutory orders as are related to the appeal judgment or final order for the proper understanding of the issue involved, together with such data as will show that the appeal was perfected on time. If an issue of fact is to be raised on appeal, the record on appeal shall include by reference of the evidence, testimonial and documentary, taken upon the issue involved. The reference shall specify the documentary evidence by the exhibit numbers or letters by which it was identified when admitted or offered at the hearing, and the testimonial evidence by the names of the corresponding witnesses. If the whole testimonial and documentary evidence in the case is to be included, a statement to that effect will be sufficient without mentioning the names of the witnesses or the numbers or letters of exhibits. Every record on appeal exceeding 20 pages must contain a subject index. Section 7. Approval of record on appeal. Upon the filing of the record on appeal for approval, and if no objection is filed by the appellee within 5 days from receipt of a copy thereof, the trial court may approve it as presented or upon its own motion, or at the instance of the appellee, may direct its amendment by the inclusion of any omitted matters which are deemed essential to the determination of the issue of law or fact involved in the appeal. If the trial court orders the amendment of the record, the appellant, within the time limited in the order, or such extension thereof as may be granted, or if no time is fixed by the order, within 10 days from receipt thereof, shall redraft the record by including therein, in their proper chronological sequence, such additional matters as the court may have directed him to incorporate, and shall thereupon submit the redrafted record for approval, upon notice to the appellee in like manner as to the original draft. Section 8. Joint record on appeal. Where both parties are appellants, they may file a joint record on appeal within the time fixed by Section 3 of this rule or that fixed by the court. Section 9. Perfection of appeal, effect thereof. A party's appeal by notice of appeal is deemed perfected as to him upon the filing of the notice of appeal in due time. A party's appeal by record on appeal is deemed perfected as to him with respect to the subject matter thereof upon the approval of the record on appeal filed in due time. In appeals by notice of appeal, the court loses jurisdiction over the case upon the perfection of the appeals filed in due time and the expiration of the time to appeal of the other parties. In appeals by record on appeal, the court loses jurisdiction only over the subject matter thereof upon the approval of the records on appeal filed in due time and the expiration of the time to appeal of the other parties. In either case, prior to the transmittal of the original record or the record on appeal, the court may issue orders for the protection and preservation of the rights of the parties which do not involve any matter litigated by the appeal, approve compromises, permit appeals of indigent litigants, order execution pending appeal in accordance with Section 2 of Rule 39, and allow withdrawal of the appeal. Section 10. Duty of Clerk of Court of the lower court upon perfection of appeal. Within 30 days after perfection of all the appeals in accordance with the preceding section, it shall be the duty of the Clerk of Court of the lower court to verify the correctness of the original record or the record on appeal as the case may be, and to make a certification of its correctness. To verify the completeness of the records that will be transmitted to the appellate court. If found to be incomplete, to take such measures as may be required to complete the records, availing of the authority that he or the court may exercise for this purpose, and to transmit the records to the appellate court. If the efforts to complete the records fail, he shall indicate in his letter of transmittal the exhibits or transcripts not included in the records being transmitted to the appellate court, the reasons for their non-transmittal, and the steps taken or that could be taken to have them available. The clerk of court shall furnish the parties with copies of his letter of transmittal of the records to the appellate court. Section 11. Transcript. Upon the perfection of the appeal, the clerk shall immediately direct the stenographers concerned to attach to the record of the case 5 copies of the transcripts of the testimonial evidence referred to in the record on appeal. The stenographers concerned shall transcribe such testimonial evidence and shall prepare and affix to their transcripts an index containing the names of the witnesses and the pages wherein their testimonies are found, and a list of the exhibits and the pages wherein each of them appears to have been offered and admitted or rejected by the trial court. The transcripts shall be transmitted to the clerk of the trial court, who shall thereupon arrange the same in the order in which the witnesses testified at the trial, and shall cause the pages to be numbered consecutively. Section 12. Transmittal. The clerk of the trial court shall transmit to the appellate court the original record or the approved record on appeal within 30 days from the perfection of the appeal, together with a proof of payment of the appellate court docket and other lawful fees, a certified true copy of the minutes of the proceedings, the order of approval, the certificate of correctness, the original documentary evidence referred to therein, and the original and 3 copies of the transcripts. Copies of the transcripts and certified true copies of the documentary evidence shall remain in the lower court for the examination of the parties. Section 13. Dismissal of appeal. Prior to the transmittal of the original record or the record on appeal to the appellate court, the trial court may, motu proprio or on motion, dismiss the appeal for having been taken out of time or for non-payment of the docket and other lawful fees within the reglementary period.